special magistrate hearing for Martin County for February 19th, 2025 at 9:01 a.m. And if you'll please rise, join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Okay, please be seated. Got a couple of cases that I'm going to take early on because we've got either folks here or a lot of staff. So the first case is a GMD case, and looks like we've got a crowd of folks here that are going to testify. Okay. All right, this is PCG 24 LLC. It's case number GMD 2024-100215. And Mr. Mitchell, you're going to lead us off?
Yes, good morning, Your Honor.
All right, good morning. If you raise your right hand, and actually you can all do that.
Swear on, sir, please.
I will. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay. Whenever you're ready.
We have Deputy County Attorney Elise Elder here on our behalf as well. I have Lindy Lassar. She is an environmental planner with the Growth Management Department Environmental Division.
Morning, Ms. Lassar.
And Daryl DeLue is the environmental administrator for the Growth Management Environmental.
Good morning, Mr. Blue. Okay, so what do we got?
Okay, my name is Jerry Mitchell, and I have been sworn in. I am a senior site compliance officer for Martin County. The respondent, PCG 24 LLC, is not present. This case concerns the property located at 2363 Southwest Carriage Hill Terrace, Palm City, in Martin County, Florida. And this case was not generated by anonymous complaint. According to the official records of the property appraisers of Martin County, the property owner is PCG 24 LLC. A copy of the property appraiser's record of ownership is marked as County's Exhibit 1.
Okay.
An aerial view of the subject property is provided on this 2024 aerial map image and is marked as County Exhibit 2. So the golf course, it's PCG 24 LLC is a golf course, Palm Cove Golf Course, and everything inside the blue is the golf course we're going to be presenting today.
All right.
I'd like to provide some background information before I proceed. On December 9th, 2005, a notice of violation was issued to the previous golf course owner for unauthorized alterations to protected upland and wetland preserve areas, as well as planted habitat areas within and around the golf course lakes. This resulted in a stipulation agreement with the county. The stipulation and agreed final order was approved by the Code Enforcement Magistrate on June 21, 2006. The recorded stipulation and agreed final order is marked as County's Exhibit 3. So the top of page here is the recorded, showing the recordation. Can you?
Recordation.
Okay, and it was to Palm Cove Golf Course LLC at that time.
Okay.
Page 2 is, whoop, go up, Daryl, please.
Nope.
Page 2 shows where the magistrate had signed it.
Excuse me.
Long time ago.
Okay. And now we're going to go to the Exhibit B. The stipulation required a revised Preserve Area Management Plan, or PAMP, for the preservation areas and the 14 lake habitat areas to be protected and maintained on the golf course, as prescribed in Exhibit B. So Exhibit B was the compliance requirements that was required back in 2006 when the stipulation was agreed. The revised, I'll pause for a second here.
Okay, I'm good.
Okay. The revised PAMP was approved in May 2007 for the golf course property. Restoration plans for the preserved areas and lakes were approved with compliance monitoring was conducted for a 5-year upon completion of the restoration activities. The site plan provided with the revised golf course PAMP details the locations of the preserve areas and lake habitat areas and is marked as County Exhibit 4. What you're seeing here is the site plan has been highlighted to identify the protected wetlands in green, upland habitats in brown, and lake habitat areas in blue.
I'm looking at green and yellow.
The blue is around the lakes. It's kind of light. I apologize.
He was asking about the yellow.
Oh, I'm sorry.
Yeah, what you're seeing is yellow is what we called brown, but those are the upland habitat areas on the golf course.
Okay.
The Habitat Restoration Plan approved in 2008 for the golf course preserve areas and lakes is marked as County Exhibit 5.
This restoration plan identifies the areas that were restored as habitat. Upland habitat is where the arrow is now.
That's the hatched area?
Yes.
Yes.
So all these marked up areas were restored. Thousands of plants were planted. The lake habitat areas include littorals within the lakes and upland habitats created around the lakes. This plan was an as-built of the 2008 restoration and includes the quantities of plants established. I counted 1,500 saw palmetto, Daryl. So a lot of plants on here.
So in this exhibit, you can see areas of what we call the littoral zone within the lake that were planted within the lake, and then an upland buffer area that was planted around the lake as the lake habitat areas. So that's identified on this restoration plan. And then these are the numerous native plants that were planted throughout the lakes and restored upland habitat areas at that time.
Okay, and that was satisfactory to the county?
Yes.
Okay.
You, Jerry.
Okay? Well, this concludes the background information and the history of the golf course. Now, 17 years later, we will discuss and introduce the present-day impacts to the preserve areas and lake habitats on the golf course that started on September 18th, 2024, and continued as documented most recently as January 30th, 2025. A notice of violation was issued for the impacts to the areas, and subsequent impacts have been documented following the issuance of the notice of violation. On September 18, 2024, the Growth Management Department received a complaint from the residents within the Palm Cove community informing us that clearing activities were occurring within the golf course preserve areas at Palm Cove. On that day, I conducted a site inspection of the golf course along with Karen Chorholm of the Growth Management Department. At that time, we observed that understory vegetation had been cleared from within the preserve areas directly behind the golf course cart barn. Also, we could see additional clearing being cleared on the property. We issued a verbal cease and desist order to the crew on site. Later that same day, I contacted Angel Gerzon, a representative from PCG 24 LLC, by phone reiterating to cease and desist all clearing activities. After that, on September 24th, 2024, a meeting was held with Angel Gerzon, his golf course architect, and his environmental professional. During this meeting, we reviewed the locations of the protected preserve areas within the golf course. Staff reiterated that the preserve areas are protected under the approved preserve area management plan, which prohibits the removal of native vegetation. Mr. Gerzon and his representatives acknowledged their awareness of the PAMP and stated that they would conduct a survey of the preserve areas. They agreed that upon completing the survey, the environmental professional would submit a restoration and replanting plan. A deadline was given of 30 days, requiring a submission no later than October 5, 2024. So at that meeting, we gave them till October 25th to try to give us something. Despite this, staff received additional complaints on October 9th and 17th of ongoing clearing activities occurring within the golf course preserve areas. Therefore, on October 18, 2024, Lindy Sarar of the Growth Management Department performed a site visit and confirmed that further clearing had occurred within the golf course property. Additionally, she documented that prohibited clearing was found within the preserve areas across from the clubhouse. Based upon the investigation and failure to cease all clearing activities in the preserve areas, I issued a notice of violation to PCG 24 LLC on October 24th, 2024, and is marked as County Exhibit 6.
Let me just ask you, do you have an extra copy? It looks like you've got a script. If I could have that, it might be easier for me to read. And I'm going to have you speak it into the record, but just to follow along.
I only brought my one.
I can share.
Give her
Yeah.
that one, and we'll share this one.
Oh, yes.
We do have a map we'd like to give you as well. It shows the photo locations to give you an idea where we're taking photos.
All right, well, okay.
It'll help you follow along what they're saying.
Okay, is it marked as an exhibit, or?
It will be an exhibit as well.
Yeah, we'll introduce that as a key exhibit of the golf course.
But right now, they're using it for demonstrative.
Okay,
Oh, you had a second one.
okay, good, thank you.
I'm sorry, that's not it.
Okay.
All right, go ahead, I'm sorry, Mr. Mitchell.
Okay, no, not a problem. In the notice, I cited the violations of the approved preserve area management plan found in the PAMP section 4.2, 5.2, and 6.0, and 6.1.
Okay. All right, and what's the,
So the section,
Gravitas there.
the section codes that we cited that they are in violation of is section code 10.14G, failure to comply with the conditions of the approved development order, land development regulations, Martin County Code, and section 4.7 violation, restoration and set aside, correction hearings, land development regulations. That's the code sections they violated. Of the preserve area management plan sections that they were in violation of, it was the 4.2, the 5.2, the 6.0, and the 6.1.
okay,
Darryl, I believe that's a little higher, isn't it? Yes. So here, so the violation reads what we're saying they're in violation of, specifically of what?
all right, so preserve areas posted with permanent signs, boundary markers, they didn't do that? Or
Correct.
did and they're gone?
They weren't there. They were not there, yes, sir.
Okay. So 5.2. Okay, thank you. Okay, all right, and then 6.0. Undisturbed, okay, and 6.1. Okay,
In
All right.
that note,
go ahead.
in the notice of violation, the respondent was given until March 6, 2025 to correct the violation and was informed the need to contact Martin County Code Enforcement upon doing so. Additionally, on October 24, 2024, I provided a copy of the notice of violation via email to Angel Gerzon and the environmental consultant, Engineering Design Construction Incorporated. On October 28, 2024, Angel Gerzon acknowledged receiving the notice. On that same day, Mr. Gerzon acknowledged receiving the notice. Staff received another complaint on the property. At that time, GMD staff members Ms. Sarar and Ms. Shorehome went to the site confirming ongoing clearing activities. Based upon the ongoing clearing activities and failure to submit a complete restoration and replanting plan, a notice of hearing was issued by certified mail on December 9th, 2024 for the January 15th, 2025 hearing and is marked as County Exhibit 7.
Okay,
The return receipt was received on December 16th, 2024 and is marked as County Exhibit 8. After receiving the return receipt, staff received another complaint on December 29th, 2024, specifically the chemical spraying and removal of lake vegetation. Therefore, on January 3rd, 2025, GMD staff inspected the property to assess the impacts to the lake habitat areas. At that time, we documented the destruction of native lake vegetation. Based upon additional destruction of protected lake habitat, I issued an amended notice of violation and notice of hearing to the respondent by certified mail on January 16, 2025, with a hearing date scheduled for February 19, 2025, and that's marked as County's Exhibit 9. So in this notice of violation, under the specifically part, we just added another bullet point to include that lake habitats have been impacted as well. The code sections are still the same.
Okay, except for 8.2. Got it.
Yeah, we added 8.2, yes, sir.
Okay.
Okay. As of January 30th, 2025, the return receipt was not received. Therefore, I hand-delivered the amended notice of violation and notice of hearing to Angel Gerzon. An affidavit of hand delivery was executed and is marked as County Exhibit 10.
Okay.
Okay, in summary, several complaints were followed by staff's site inspections on the following dates in 2024 and 2025. On September 18th, October 18th, October 28th, December 17th, January 3rd, and January 30th. The site inspections documented the continuing and cumulative impacts that occurred to the preserve and lake habitat areas following our meeting on September 24, 2024, with the property owners' representatives. We have seen heavy equipment repeatedly clearing the protected areas and have documented impacts to wetlands, upland preserves, and multiple lake habitat areas on the golf course. This is the key map. A key map exhibit of the golf course has been printed for the magistrate, which we had the bailiff just hand you. And we also have it marked as County Exhibit 11. So
Okay.
that matches what you have. Yes, sir.
Which,
Yes.
both?
Both of them. There's a north and a south golf course. The larger map with the more lakes and is the north property, and the other one's the south property. Hopefully that helps ID the locations as we present our photos.
Okay.
The county property appraiser has historical bird's eye aerial property photos on their website. County's Exhibit 12 is taken from the property appraiser's website and is provided to show an aerial view of locations 1 through 5 as identified on the key map exhibit. The image is dated December 18th, 2023, and this is prior to any clearing violation. So what we're depicting here in this aerial view is that you can see the areas that are in box is upland habitat areas, and we're showing that they are vegetated in this picture.
Okay.
On September 19th, 2024, I conducted an aerial inspection of the property with the Sheriff's Aviation Unit and took photographs. The photographs accurately depict what I saw as locations 1 through 5 on the key map and are marked as County Exhibits 13 and 14. So in 13, we're just showing how you can see that understory clearing has occurred within these boxed areas. These box areas aren't to scale, but that is the area of upland habitat that is within the preserve area management plan that has been approved for the site. And Exhibit 14 is just more the same at a different angle. You can see where, again, the understory has been removed from here. Understory vegetation.
And was there a requirement that the understory be maintained?
In the preserve area management, it does require that it be maintained, and that, but the thing is the importance of it is to retain all native vegetation.
Okay.
So these upland habitat photos that you're looking at, like Area 3 and Area 2, you're seeing a tree canopy, but that's just part of the upland habitat, which also includes understory native vegetation and native ground cover. And in particular, there was saw palmetto vegetation established underneath these trees you see here.
Okay.
That really is the vital habitat where all the animals live. They don't live in the trees so much.
Okay.
Okay. On October 18, 2024, Lindy Sarrar of the Growth Management Department performed a site visit and confirmed that additional clearing was occurring within the southern golf course property, as reported by the neighboring community. She took an inspection photo of location 6 to document these impacts to the Upland Preserve as marked as county, and is marked as County Exhibit 15.
In this photo, you can see the impacts to the Upland Preserve and the South Golf Course where saw palmetto, which is, like I said, where really that's the vital habitat. That's the longest-lived plants. That's where all the animals nest and everything, has been mechanically removed and shredded. I was at the property line between the neighboring Oak Ridge community that had reported clearing. Their preserve abuts the golf courses, and the people were calling us a lot about that.
Additionally, she documented that prohibited clearing was found within the preserve area across from the clubhouse identified as photo location 7 and is marked as County Exhibit 16.
You can see where the habitat was removed. Some of those little plants coming up are the saw palmettos, and you can see where they were ground down, and the pine trees have been impacted with the branches on the ground. So all the understory was removed.
An inspection photo of equipment as seen on the golf course at the time is marked as County Exhibit 17.
So on that inspection, we found this equipment. We told them to stop again, which they didn't. But this is, see the grinding blade? That's what we think did most of the damage, equipment like that. You're not allowed to use equipment at all in preserve areas.
Yes. Okay, right.
In a subsequent inspection on October 28, 2024, Lindy Sarrar and Karen Shorehome of the Growth Management Department confirmed that clearing had occurred within the wetland preserve areas on the golf course property. County's Exhibit 18 is taken from the property appraiser's website and is provided to show an aerial view of locations 8 and 9 as identified on the key map exhibit. The image is dated November 23, 2023, prior to the clearing violation. An inspection photo of location 8 was taken by Ms. Sarrar to document impacts to Wetland 2 and is marked as County Exhibit 19.
In this photo, you can see the impacts to wetland preserve where the native vegetation has been removed by equipment. You can see tracking with heavy equipment and vegetative debris. This is a flyover that's allowed to be trimmed by hand to like waist height of the mangrove so they can tee off and hit the other hole, but they're not allowed to grind it to the ground as they did.
Okay.
And we're going to just add there, although limb trimming is authorized in the golf flyover area of the preserve, the alteration and destruction of mangrove trees that were documented in this area do not comply with the scope of trimming activities that could have been permitted. A close-up photo of an impact mangrove area is marked as County Exhibit 20.
And you can see a mangrove tree, pretty good size, ground to the ground.
Okay.
An inspection photo of location 9 was taken on January 30th, 2025 by Ms. Sarrar to document impacts to Wetland 2's protected buffer area and is marked as County Exhibit 21.
So you can see impacts to the mangrove and the buffer. We have a buffer next to that wetland, and that buffer is all gone. And probably by heavy equipment again, the way the trees are chewed up there.
On February 12th, 2025, I conducted an aerial inspection of the property with the Sheriff's Aviation Unit and took photographs. The aerial photograph actually depicts what I saw and of locations 8 and 9 on your key map and is marked as County Exhibits 22. The locations of the wetland and wetland buffer impacts from the previous 2 exhibits are identified on this aerial flight photo.
Okay.
On December 17, 2024, Lindy Sarrar and I performed a follow-up inspection. Exhibit 23 shows the December 18, 2023 bird's eye view of Wetland 5 and adjacent lakes 7 and 8 before clearing occurred. So again, it's another bird's eye view before the clearing occurred. Exhibits 24 and 25 taken by Mr. R depict clearing of wetland 5 vegetation with heavy equipment.
Wetland vegetation and wetland soil are evident in this photo, and it shows impacts as seen as ruts in the soil from the heavy equipment and piles of mulched vegetative debris. And now we're looking the other direction over the same wetland. It's a long, thin wetland there.
Piles of removed vegetation were later seen deposited along the wetland 5 on January 3rd, 2025 inspection, and is shown in Exhibit 26. Just the debris has been just laid there. On February 12th, 2025, I conducted an aerial inspection of the property. The aerial photograph accurately depicts what I saw as location 10 on your key map and is marked as County Exhibit 27. What this exhibit is doing is just showing the cleared areas along the wetland and along around the lakes as well.
Okay.
On January 3rd, 2025, Lindy Sherrar and I performed a site visit to document damage done to the lake habitat areas. Clearing impacts were seen throughout all of the lake habitat areas. Exhibit 28 shows the December 18th, 2023 bird's eye view where you can see native vegetated areas established around the northern golf course lakes before the impacts occurred. Exhibit 29 is taken from Lake 9 at location 11 as identified on the key map.
You can see the cut and mulched saw palmetto in the foreground and killed, likely chemically sprayed littorals in the background near a home. Littorals are the ones in the water. The removed vegetation can be seen lying in the lake, and decaying vegetation can negatively affect water quality in the lakes.
Exhibit 30 is taken from Lake 10 at location 12 as identified on the key map.
On this lake and in many of the cleared lake habitats, I observed algal blooms such as you see here. So when dead plant debris enter the water, the decaying process removes the oxygen and degrades the water and affects the fish and everything else.
Okay.
Exhibit 31 is taken from Lake 1 at location 3 on January 3rd, 2025 as identified on the map.
You can see again the remnants of the removed saw palmetto. There were hardly any left on the golf course. And the littoral plants were removed as well.
27 days later, on January 30th, 2025, Lindy Sherrar witnessed equipment digging up saw palmetto roots around the same lake depicted as County Exhibit 32.
I saw a small bobcat, which I have a video of, that was digging up and piling up the saw palmetto roots. This photo depicts further destruction and excavation to the lake habitats. Saw palmetto can be cut down and sometimes will come back, but not if you dig up the roots, it's gone.
And just to be clear, I mean, you already had given them a stop work order.
Correct.
And what was the date of that?
We originally went out there on September 18th and told the crew to stop, and the same day I did also had phone conversation with Angel Gerzon, a representative of PCG 24, and asked him to cease all activity. We also held a meeting with him on September 24th, 24, in our office, and again, we told him and his representatives to cease all clearing activities until we get a approved restoration plan from them.
All right, so now we're 4 months later and they're still,
Yes.
We did call Florida Wildlife Commission. They went out because I found some gopher tortoise burrows, and I was afraid those would be impacted. But we called, the building department was involved because we saw some unpermitted work.
In conclusion, continued impacts to the northern and southern golf course habitats were documented from September 18th, 2024 through January 30th, 2025. On February 12th, 2025, I conducted an aerial inspection of the property. The aerial photographs accurately depicts what I saw in the northern golf course as marked as County Exhibit 33. Just a good overview of, you can see all the lake habitats that's been removed around each lake. It's just reiterating what we've been explaining all through the other exhibits.
This is Exhibit 34 of the southern golf course area where you can see additional impacts in this location here. There's another wetland area that was cut down, a flyover area. And you can see other impacts in the upland preserve here and over here in this photo of the south course and around the lake up here.
Okay, I see the damage. Do we know when those actually occurred? I mean, is it possible that they occurred before the work stop order?
No, well, this area in particular here, we presented evidence. We received complaints from this neighboring community, and I think it was Exhibit 6 that we showed you early on where Ms. Sarar was out because these neighbors were complaining. They have a preserve area located here, and they started going in and cutting right next to their preserve, and this is part of the preserve in the southern golf course habitat. And what was the date that we...
I think that was the
That was
18th.
observed on October 18th, 2024.
So after the work stop order, I guess what I'm trying to determine is how egregious is this? And I see it's substantial, but I'm trying to determine how much of it was done after the work stop order was issued.
They just kept going. And we would go out there, and the guy Angel was there and would smile at us and let us use a golf cart, but they just kept going, even though we told them to stop. It
So-
seemed like they ignored us totally.
So from September,
September 18th, they were
18th.
first told to cease.
but from that date on, all of your visits, you observed new damage?
Correct.
Okay.
There was even herbicide spraying. I couldn't tell for sure if it was on the native plants or just weeds, but the places they had cleared, they'd gone back, and I'd seen the dye and the herbicide. They just wanted to get rid of all that understory. In the littorals, I mean, we had quite a lot of upset people.
Anybody here on behalf of PCG 24 LLC?
Nope. I had conversations with Angel. I even offered him a proposed stipulation agreement, and he never responded.
And who is Angel?
Angel Gerzon tells me he is a partner within the PCG 24 LLC Corporation.
Angel Gerzon. Okay. Have you done like a Sunbiz check on PCG 24 LLC?
I did, I did do I can't recall exactly who was on that at the moment, but I mailed the certified mailing, and all the mailing went to the correct mailing address as per the tax collector's office and the property appraisers.
Okay. All right. Go ahead, you can,
I was going to say, Mr. Gerzon was very cooperative, very talkative. He just didn't tell his people to stop. The preserve area management plan that you have up there, the recorded document, we don't have it as an exhibit in the PowerPoint, but I'd like to add that as Exhibit 35 for the county.
okay, and these larger maps?
Yeah, they were presented as exhibits.
Okay,
Just the
go ahead.
recorded PAMP was not.
Yeah, you're not done. Go ahead and finish.
I got to close it out here. Based upon the testimony and evidence, I request that the respondent be ordered to comply with the cited provisions of the Martin County Code by the compliance dates outlined in the order. If not in compliance by then, be required to pay a fine in the amount of $500 a day per violation per day, 2 violations. If not, if the violations continue thereafter, the county has incurred a cost in the amount of $575 conducting this investigation and requests that the county be reimbursed this amount at the conclusion of today's hearing. And that concludes my testimony, or our testimony at this time.
Okay. And just for clarity, these are in the exhibits?
Yes, sir.
Somewhere. Okay. All right.
So So on the order, just real quick, we gave them 90 days to submit to us by May 21, 2025, to submit to us a complete restoration and replanting plan for all the impacts on the property. And that needs to be approved by that date. And finally, we gave until another 90 days by August 19, 2025, to completely have it planted and provide us a bond and get a satisfactory pass inspection by that August 19, 2025 date.
Okay, and what makes you think that they won't just continue to clear these areas?
That's a good question. We don't know. The one thing I can say is I don't think we've had any new complaints lately.
I think they've cleared most of it already. They haven't gone deep into the wetlands as far as we know. They've just done all the edges of all the preserves, it seems.
And the
Okay,
lakes.
so is the thought that they've done what they intended to do, and,
We can only assume that, yeah.
I did see some non-native plants planted in the edge of the preserve. So I think it seems like they're going ahead with they're building a fancy golf club building there. They have statues. They have all that under construction. The HOA community is pretty upset with the whole scenario as well.
okay. My recollection is that when I find that they've done, not irreparable damage, although that's one of the factors, but where it's particularly egregious and intentional, that I can actually amp up the fine. My inclination is to do that in this case. I think there's enough evidence of that.
We concur.
What I don't recall is exactly what the amounts are.
Well-
My memory says that it can go up as much as $5,000 a day, but,
With the initial one, it'll be $1,000 a day.
okay.
A repeat violation would be up to 5. Yes. This is not a repeat,
And you were asking for 500,
correct,
okay.
for each violation, yep.
And have you calculated the number of violations?
2.
There's 2 violations that we cited, 10.14G and also 4.7. Yes, sir.
All right, but there are many examples of each of those.
Yes. Yeah, we got 14 legs worth of it, and we also have about that number of, if not more, of upland habitat
All right.
and wetlands.
I'm going to find that the violations are particularly egregious and substantial and impact this community potentially severely. In that case, I'm going to find that it's appropriate to have a fine in the amount of $1,000 per violation per day for continued violation of the order. And just to tidy things up, I'm going to accept into evidence the county's exhibits 1 through 35 without objection, since no one's here. I'm going to find that violations as charged do exist on the property, and I'm going to find, because of the egregious nature of the violations, that a fine in the amount of $1,000 per violation per day is appropriate. And I'll order compliance on or before, beginning in May of 21st, 2025, as stated in the draft order, and then completion on or before August 19th, 2025. Okay.
Yes, sir.
Let's see, let me just. Okay,
Thank you very much.
Thank you, Ron.
thank you. I'm sorry you're having to deal with it, and I'm sorry the people of Martin County are having to deal with it.
Thank you.
Thank you.
You,
You can go around. You can go around.
okay, oh, here. I'll give you these back, too. Oh, one more thing. Exhibit 35. All right, our next case is the Perez case. It's ENF 2024-060650, and the respondents are Elaine and Julimar Perez. And anybody here? You are here. Okay, good. Okay, the way this works, we're going to hear from the county. It's a violation case. At the conclusion of their presentation, then I'm going to talk to you about it. I'll swear you in at that point. You can stand there and look at that monitor, or you can sit in that first row and look at the monitor right above you. Either way is good.
Thank you.
Okay. Let's see. I've got to swear in Officer Counselor. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. And whenever you're ready, let's see, this is 6-5.
My name is Chris Counselor. I've been sworn in. I am a code compliance investigator for Martin County, Florida. The respondent, Alan Perez, is present. This case concerns the property at 4614 Southwest Citrus Boulevard, located within Palm City, located within Martin County, Florida. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owners are Alan Perez and Julimar Perez. A copy of the property appraiser record is County Exhibit 1. On July 15, 2024, Officer Frank Marcos inspected the property. At the time, he observed unpermitted pole barn, shed and fence, and an RV being used for living purposes. At the time he photographed the property, the photographs accurately show what he saw then is marked as County Exhibit 2. A screenshot and aerial from 2018 and 2024 showing unpermitted structures will be County Exhibits 3 and 4. So 2, Frank just left a door tag.
Okay?
3 is in this horseshoe area, basically the highlighted areas are the unpermitted structures. We have a pole barn, and then back here we have a fence and a shed in those areas.
Okay.
That's County Exhibit 3. And Exhibit 4 is from 2018 showing no structures in the circle up here and no pole barn down in this section down here.
Okay.
Based upon the investigation, Officer Frank Marcos issued a notice of violation to Alan Perez and Julimar Perez on July 24, 2024, marked as County Exhibit 5. In the notice, he cited the following Martin County Code violations. Section 105.1 Florida Building Code for permits required. Section 3.201.c.2.h for RV being used for living purposes. Section 123.2 for local business tax. And Section 3.11 for permanent uses for non-ag use being used on the property. I guess the initial complaint was that a van they were customizing vans at the property, but I've not had any evidence of that. So in the notice of violation, the respondent was given until August 30th, 2024 to correct the violation and was informed of the need to contact code enforcement upon doing so. I took over the case in October of 2024. On October 2nd, 2024, I inspected the property. At the time, I observed the unpermitted pole barn, the shed and the fence, and the RV parked in the back of the property being used for living purposes. At the time I photographed the property, the photographs accurately show what I saw then and marked as County Exhibits 6, 7, 8, and 9. So we'll go through. 6 is the pole barn in question. Exhibit 7, this is the RV in the back of the property. Exhibit 8 is the fence. Exhibit 9 is another section of the fence.
Okay.
With a screenshot of the permit history of the property being in County Exhibit 10. No permits for pole barn, accessory structures, sheds, or fences listed for the property history. Based upon the investigation, I issued an amended notice of violation to Alan Perez and Jolamar Perez on November 20th, 2024, marked as County Exhibit 11. In the amended notice of violation, I updated the codes based on what violations I saw, which would be Section 105.1 Florida Building Code for permits required, and Section 3.201.c.2.h for the RV being used for living purposes. In the amended notice of violation, a respondent was given until December 20th, 2024 to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved, and a notice of hearing was issued by certified mail on January 29th, 2025, and is marked as County Exhibit 12. My notice of hearing for today's date. The return receipt was not received, so on February 6, 2025, I posted the property. A photo of the posting and the affidavit of posting are marked as County Exhibits 13 and 14.
Excuse me.
Yeah.
Forgot to turn that off.
Okay. 13 is the posting on the side gate, and Exhibit 14 is my affidavit of posting. No call or letter has been received in time. No call or letter from the property owner has been received in time allowed. Therefore, I went to the property again on February 18, 2025, and saw that the cited violations had not been corrected. At the time I photographed the property, the photographs accurately show what I saw then, and marked as County Exhibits 15, 16, 17, and 18, with a permit history of the property being Exhibit 19. So 50 is the pole barn in question at the front. Exhibit 16, the gate still, the fence and the gate in the back. 17, the RV still there. 18, this is the shed behind the camper. And Exhibit 19 is the permit history showing no permits for fences, sheds, accessory structures, or pole barns.
Just for the public and for you, sir, this exhibit and the one that we saw before, for whatever reason, seems to be washing out on the screen, but I can see it on the computer. So I'm actually reading it and can verify that what the officer said is correct. And although I don't know how you could tell by looking at the screen that's shown there. And I know the county is working on this issue because it didn't do this in the past.
I requested all county's exhibits be received into evidence. Based upon the testimony and the evidence, I requested that Respondent Alan Perez and Jolamar Perez be ordered to comply with the cited provisions of the Martin County Code by March 31st, 2025, and if not compliance by then, be required to pay a fine in the amount of $100 per day per violation until compliance is achieved. The county has incurred the cost of $575 conducting this investigation and request that the county be reimbursed this amount at the conclusion of today's hearing. And that concludes my testimony.
All right, looking at Exhibit 17. How did you determine that the RV was being lived in?
Basically, just the awning's been up, and at different times the antenna's been up. But I've had no contact with the property owner up until today to discuss the violation, so.
Okay. So no evidence of power cord or
No, sir.
sewage line or water?
No pictures of
Okay,
that.
all right. Okay. All right, sir. If you'll raise your right hand, do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God. And your full name, sir?
Alan Perez,
And your address?
4614 Southwest Citrus Boulevard.
And you're the owner of the property along with your wife,
My
is
wife,
that?
yes.
Okay, all right. So you've heard what the county has to say. I think probably the pole barn without the permit is an easy issue. I'm wondering, and the fence probably as well, but tell me about the RV. What's the situation
The
there?
RV we use as basically the central office for my wife's dog sitting business. There's nobody living in there. There's no connections on it. It's just basically a place where we received the dogs and host the dogs during the day while my wife is doing the dog sitting.
Okay, so it is occupied?
Yes.
Okay. All right, I think that may be an issue as well. Let's see. What do you have to tell me? Anything?
I mean, I understand, sir, Officer Chris. I spoke to, originally when I received the complaint back in July 15th, there was another officer, I believe he said his name was Marco. I tried reaching him then to go about correcting the issues going, and I called multiple times. He would never get back to me. I went into the office one time, he told me he was out on the field. Then the last time I called, they told me that he was no longer in the office, he was no longer with the county, that the new officer will reach out to me. I've never heard back from Mr. Chris until I received this letter in the mail about the hearing. So I've never had a chance to correct the issues. So if I could have an additional 30 days, I have no problem correcting the issues with the
Well,
violations.
I would suggest to you that if you are starting from scratch and need to get a building permit for that pole barn, it's going to take more than 30 days.
That's the thing, that pole barn was there when we purchased the property,
When did you purchase?
November 22, November of 2022.
And of course,
The appraisal shows that that pole barn was there.
and you probably realize, I don't know whether anybody's told you this, but if the prior owner didn't get permits for that structure, then you're at risk. And they're supposed to disclose that at closing.
I believe the reason is that they had an ag exemption prior and might have expired when we took over the property.
If it's a building for agricultural use, it could be exempt depending on what's in it, but is there power to that building?
There's no power, but all I based it off was this, what's currently, there's no ag credit on the property existing. So I'd have to do additional research to see the time frame of when he purchased the property and go back and do that research.
All right,
But the fence and the shed, both were definitely built recently under his ownership.
yeah, so you still are going to have that violation no matter what, depending, the pole barn might, depending on how it was done and under what use and that sort of thing, may not require it. I think what I'm going to do is, there's enough there. I can find the violation. I'm going to do that, but I'm going to give you a while to comply before a fine kicks in. That should give you enough time to work with Officer Counselor and the building department to get whatever you need to do and give them an opportunity, actually, if they can come on the property, to make a determination regarding the need for a building permit for the pole barn, which may or may not be necessary. And then, but for the shed and for the fence, those should come out pretty quickly, the fence and the shed permits. But then the RV, I don't think you can, you can't live in it, and I don't think you can have a commercial use of it. Even though it's kind of an auxiliary use, but even that remains to be seen because of the new home occupation statutes that are
Correct.
out there.
Is it-
So,
I believe, Your Honor, that the ordinance 3.1 defines use of an RV as to not only sleeping, but any occupancy, but I don't have the text of the statute here, so
no, and my recollection is occupancy
any
as well,
occupancy,
and
it
not,
doesn't actually have to be lived in, just any occupancy.
sleeping would be one indication of occupancy, but I don't think you're going to be able to use it unless the Florida legislature last year changed the law on home occupation, so it's possible, but I don't know the answer to that. All right, so I'm going to find and I'm assuming you don't have any objection to the exhibits that the county presented? All right, so without objection, I'll accept those into evidence 1 through 19. Based upon the evidence, testimony of the officer, in your testimony, Mr. Perez, I'm going to find that violations as charged do exist on the property. I'm going to order compliance, I'm going to say May 31st. And that'll give you hopefully ample time to get all of this straightened out and figured out. If you don't do that, then it will be $100 per violation per day. But again, hopefully that all resolves. And unfortunately, there are costs in the amount of $575. Those do need to be paid. I mean, that's basically for this hearing and bringing us all here. And I'm sorry that you weren't able to connect, but it probably would not have mattered under the circumstances. I probably needed to hear this case. So those will be awarded to the county and payable basically at the conclusion of the hearing. So I'm going to go ahead and enter this order, but as I say, it'll be May 31st, not March. And, okay. All right. Do we have does Officer Counselor have a good way to reach you, email or text, cell phone?
I will make sure to give them my
Yeah,
number.
give them all of that before you go, and then that way you'll be able to connect directly.
Yes.
And hopefully get all of that taken care of.
Absolutely.
Okay. And I can give you a copy of this order before you go if Ms. Bradley will make sure you get that, okay? You just check with her. All right. The third case that we're going to take is the Soto Trust case. And it's case ENF 2024-101018-01, and the respondents are Soto Trust and 5 Color FL LLC trustee, as trustee for the Soto Trust, I'm assuming. All right, and this is, Ms. Bush, that's your case?
Yes, sir.
And sir, if you're here on behalf of the trust, are you the trustee? Or,
My name is Eric Ott. I am the trust.
I'm going to swear you in before you do anything. Let's listen to the county. This is a violation case. Let's hear from them first. And then I'll swear you in, and then you can tell me what you need to tell me, okay?
Are you starting the hearing?
I am starting the hearing.
I object.
To what?
The hearing?
Oh, okay, fine. That's your request is denied. Ms. Bush, if you'll swear. Sir, quiet, or I will
Okay.
end the hearing.
Okay, that's what I'm asking.
Yeah, no. Ms. Bush,
Okay.
do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
All right. What have you got, Ms. Bush?
My name is Tamika Bush, and I have been sworn in. I'm a co-compliance investigator for Martin County. The respondent, Soto Trust, is present. This case concerns the property at 1507 Northeast Satong Avenue in Jensen Beach, Florida, 34957 in Martin County, Florida. This case was not generated from an anonymous complaint, and according to the official records of the property appraiser of Martin County, the property owner is Soto Trust. A copy of the property appraiser's record of ownership is County's Exhibit 1.
Okay.
On October 28, 2024, the property was inspected, and at that time, code enforcement investigator observed overgrowth, a fence in disrepair, and inoperable vehicle. At that time, the property was photographed. The photograph accurately shows what was seen then and is marked as County's Exhibits 2 through 4. County's Exhibit 2. And that's overgrowth and the fence in disrepair. County's Exhibit 3. An additional photo showing additional overgrowth outside of the fence. County's Exhibit 4, which includes the overgrowth, the fence, and the vehicle.
And the vehicle is,
Well, part of that tree is actually on the vehicle. At this time, it has complied, though.
okay.
It is in compliance. Based on the investigation, I issued a notice of violation to Soto Trust on November 5th, 2024, marked as County's Exhibit 5. In the notice, I cited the following Martin County Code violation: Section 67.201A, nuisance declared, weeds and undergrowth; Sections 21.99, accessory structures; Sections 91.34A, generally inoperable vehicle. In the notice of violation, the respondent was given, which is Exhibit 5. In the notice of violation, the respondent was given until December 5th, 2024 to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved, and a notice of hearing was issued by certified mail on December 30th, 2024, and is marked as County's Exhibit 6. At that time, the only remaining violations was Section 67.21A. The remaining violations were in compliance. The return receipt was not received, and the property and county administration building was posted on December 30th, 2024, and is marked as County's Exhibit 7. And that's the affidavit of posting. On January 31st, 2025, I received an email from the trustee of the property showing that the wrong notice of hearing was placed in the certified mail regarding the January hearing. Based on the email, an amended notice of hearing was reissued on January 13th, 2025 for the February 19th, 2025 hearing. And it's marked as County's Exhibit 8.
Okay.
While out at the property, additional violations was found on the same parcel. A screenshot of the property is marked as County's Exhibit 9. A permit screenshot of the parcel is marked as County's Exhibit 10. Which shows no open permits or any fencing permits.
Well, there is an expired permit. Is that for the fence?
That was back in 2016. It was for a residential fence. There was also one back in 1994. The photos that I will show you will indicate that the fence is not from 2016.
Okay.
Photos were taken of the violations, which is a clear and accurate representation of what I witnessed, and are marked as County's Exhibits 11 through 15. Exhibit 11.
All right, and what are we looking at there?
So basically on Exhibit 11, it also shows a little bit of the fence, which I'll show you a better picture of that. And it also shows the garbage, trash, junk, debris, or unsightly material. County's Exhibit 12. And that's additional photos of the unsightly material. County's Exhibit 13 is the trash. County's Exhibit 14. You can see the fence that was not done in 14 or 16, and then more of the unsightly material in this photo.
You basing that on the color of the fencing material?
Basically, you can see where, I'll show you, where the difference of the fence is and what's there and what was placed. Yes, sir. Which there was never a fencing permit because the original permit expired, so that one wasn't.
What is 15?
It's just additional photos from a different angle of the fence as it go down the side. Therefore, I sent an amended notice of violation and an amended notice of hearing for February 19th, 2025 hearing, and it's marked as County's Exhibit 16 and 17. And this is the amended notice of violation. Exhibit 17, the amended notice of hearing for today's hearing. And in that notice, I cited the following Martin County Code violations. Section 67.201A, nuisance declared weeds, undergrowth, general ordinances of Martin County Code. Section 67.201B, nuisance declared trash, etc., general ordinances of Martin County Code. Section 105.1 FBC, permits when required, incorporated by Section 21.1 general ordinances of Martin County Code. The return receipt was not received, and the Property and County Administration Building was posted on February 7, 2025, and is marked as County's Exhibit 18 and 19. Exhibit 18 is the posting, and Exhibit 19, the affidavit of posting, sir. Therefore, I went to the property again on February 18, 2025, and saw that the cited violations had not been corrected. At that time, I photographed the property. The photographs are shows what I saw then, and is marked as County's Exhibits 20 through 26. Exhibit 20 shows that the overgrowth remains. Exhibit 21 is a photo of the storage of the unsightly materials. The fence still exists. And other items in the fence as well. Exhibit 24. And Exhibit 25.
Okay.
Exhibit 26 is just that this side of the fence remains as well. I request that all of the county's exhibits be received into evidence, and based upon the testimony and evidence, I request that the respondent, Soto Trust, be ordered to comply with the cited provisions of the Martin County Code by March 31st, 2025, and if not in compliance by then, be required to pay a fine in the amount of $100 for every violation, for each violation every day that the violation continues thereafter. The county has incurred a cost in the amount of $575 conducting this investigation, and requests that the county be reimbursed this amount at the conclusion of today's hearing.
Okay. Sir, if you'll raise your right hand, do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Okay, and your full name, sir?
Eric Ott, I am the trustee for Soto Trust, the real property noticed here, and the enforcement.
Okay, and Mr. Ott, what do you have to tell me?
I object.
Object, Your Honor, before I start, the property appraiser indicates the trustee is a corporation named 5 Color Fill. If we get what the respondent's association with that corporation is?
I'm trustee for both. My address, 26 North Sewells Point Road, is that of service recognized by code enforcement. And I do object to this hearing based upon due process, sir. Above and beyond the fact that I would love to know how to communicate with a magistrate for scheduling or whatever purposes independently in the future, as I am unavailable March 10th through the 26th. I do believe that this process does not provide due process. And my basis for this is very simple and direct. There was a notice given by code enforcement of Martin County, as indicated here, February 7, 2025, for the 1507 Northeast Satang property only, citing, and I will give a copy of, General Ordinances, Martin County Code, Section 676.202.c. Yes, you may have a copy. I can read mine if you'd like, just so it's easier.
Okay. Thanks.
Yes, sir. I saw in the other hearing it was just easier to follow along than,
Might I take a look at it first before we? Unless you want to see it first, Your Honor.
No, you look at it first, then I'll.
No objection.
Okay, so tell me what I'm looking at.
yes, sir. General Ordinances of Martin County Code, Section 676.202.c. Content of notice to abate, in this case dated February 7, shall contain for a hearing date at least 15 calendar days after the date on the notice. This date would be, I believe, February 26th or later. This is in addition to what I find are numerous public records violations. Interestingly, Ms. Bush just represented all kinds of evidence you want submitted here on a hearing that I don't think follows due process, that she hasn't produced in public records after multiple requests. So I'm at a huge disadvantage here.
You are, I
Numerous-
think,
numerous
because you
issues.
don't quite understand the law, at least in this particular instance. I don't know that Section 676.202C has anything to do with what we're doing here.
Or I'm sorry, did I do is it 67? Are we?
I don't know, I'm reading what you said, section,
I'm sorry, 67. I made a typo. 67.202.
okay,
67.202. My error, I apologize.
okay. So it should be 67.202. 67.202,
Yeah.
67.202, of course, is part of the section that was cited. And if you were given a notice to abate, which is a different process than what you're here under, then I agree that it had 15 days, calendar days notice in it, but that's not what we're doing here. And that may be part of the misunderstanding. Let me just explain to you. You've had due process. Due process in this case constitutes basically an opportunity to be heard for the violation that's been cited. And it's a pretty simple process. It's different than the state court process. For instance, there is no discovery here. The case doesn't proceed the same way that a case in court might proceed. It's an abbreviated, simple opportunity to be heard. You were welcome to bring any evidence that you thought was relevant. You've done that, but unfortunately, this doesn't pertain in this particular instance. So the violations, let me get back to that, and I'm going to ask you first, do you have any objection to the exhibits that the county's presented, 1 through 26?
Yes, I object to all the exhibits. As late as just yesterday, multiple requests to communicate with Ms. Bush, Ms. Bradley, Mr. Calando have fallen on deaf ears. My form of discovery is Florida Statute 119. Requests which have not been produced, one of which was not even responded to.
Okay.
Now, my
Hang
discovery
on.
should be.
Let me just word dire that. Let me ask you,
I should
have you
a-
all received a public records request?
Yes, I believe Ms. Bradley could testify
All right.
as to this.
Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right.
So we did receive the email from Mr. Ott. I forwarded it to our Public Records Department. Our Public Records Department forwarded it back to us to put in a folder to release to Mr. Ott, which I did yesterday morning. I can't control when they release it, but I did submit it back to them.
Okay, so the records were actually forwarded to Ms.
They were forwarded to Public Records to release to Mr. Ott.
Well, that's not very helpful if the hearing is today.
Well, I received it yesterday morning for the request.
Okay. All right. So it's not an immediate thing? I don't have any problem continuing this hearing for 30 days?
Your Honor, if I just might ask a question to the witness?
Yes.
Ms. Bradley, was that the first public records request you received from Mr.
Yes.
Ott? Can you inform this court of any others?
That is, I believe, the second public record request that we have filled for Mr. Ott. The only change to this one was the last exhibits, which was the amended notice of hearing and violation, and then her day before pictures.
Okay.
Objection there.
Still a little late,
Very.
but nonetheless, your request is late.
I made multiple requests. I got a hearing notice here with multiple new issues that were supposedly corrected, even in her own words. She's presenting pictures that have already been corrected. On the 7th of February, I, as quickly as possible, communicated with the department, specifically in emails, not to have any voice communication to get confused, to Mrs. Bush. The statement that the public records requests have been produced is false, sir.
Okay, do you
It is
have?
false,
of-
and I don't have.
Wyatt, do you have record of
I have
Mr.
my email
Ott's
showing where it
emails?
was sent.
Okay.
And the other file, as she says, has never been received. I do not have.
What are you anticipating doing here,
I'm going to show
Ms.
you the
Bradley?
email where they sent it to me, where I forwarded it to Public Records. Public Records send it to us. I can show you where I responded, letting them know that
Okay.
it was done.
I understand, though, that if it's a public records request, that's not necessarily going to be dispositive of any issues other than the fact that you sent it to them and they did whatever they were going to do. It's a different office, obviously. I don't think Mr. Ott is saying that you did anything wrong. I think what he's saying is he didn't get the information.
Well, and like I said, I sent it to Public Records. I don't know what their time frame is for releasing
Exactly,
the information.
exactly. And if you request it the day before the hearing, chances are very good you're not going to get it.
There were multiple requests prior, sir. Multiple.
Okay,
One of which there
then
was
that's-
not even a response. Now, if I may
We'll
just
see.
suggest a little disorganization here. In 30 years nearly as a resident in Martin County, I've never been here. I have multiple properties I'm responsible for as trustee. All issues, as Ms. Bradley knows, as Mr. Clounder knows, I've always worked to resolve. Always, 100%. I'm disappointed. I've never been here. I've tried to communicate. These late dates were pressed on me, forced upon me, in violation of process, statute, constitution, et cetera. I can't help it that I'm responding to a notice received on the 7th, which was a Friday, and had to wait until 9th, 10th, 11th to try and start the communication. This wasn't just a yesterday, okay? It was them responding yesterday and making this a last minute. I'm just asking for help. Now, we could dismiss this entirely, you have the power, but another thing, maybe for April, if they organize, come back, we won't even come back. I'll have everything taken care of. But I don't see any, you say due process has been met, but we're indicating public records have not been produced. I'm at a huge disadvantage here.
No.
I don't have the ability to even respond when they don't even help me with particulars and details of what's going on. So all of this has created tremendous confusion for matters which she's already said have been complied for. And I have emails which indicate this real property has been complied from Ms. Bush
No, sir.
and Ms. Spradley with respect to the mowing of the yard, with respect to the fence, the repair was made. Ms. Spradley indicated no permit necessary. But all of these things, based upon the due process, that we should not have a hearing until at least 15 days from this February 7th here, really, it starts to
That does
eliminate the
not
whole,
pertain, okay? It's not,
this is
pertinent.
code for Martin County.
it is code for Martin County, but it pertains to something else.
What does it pertain to
The
then?
notice of abatement, which
Right.
is not what you were given.
The notice of abatement is essentially right here, the notice of violation, which is attached to the notice of hearing.
No, those are different.
Components.
Those are different. The notice of abatement says, we, county, are going to come in and fix your property if you don't do it. That's a different process. So
So what are the guidelines?
that may be an option incidentally.
Violation then if we're not even following a minimum 15 days? Because the other part of this code indicates that there will be correction within 15 days. So within this February 7th, Within
you know
the
what?
15
We're taking a
days.
lot of time here for argument that isn't going to go anywhere. I mean, you don't have a right to tie us up for the entire day.
well, then let's go issue by issue, and I'll do my best just to go issue by issue and show how they seem to be wrong, although I object to the due process here as a violation of my rights to have had these public records as a matter of discovery for this hearing and understand what code enforcement is talking about. But if you would like to, at the disadvantage of not having produced the public records and in violation of what I recognize as Martin County's own code, then let's proceed with what seems an illegal process. And I will do my best to go through every little line item here. Let's start with number,
As I started to say before you interrupted, my inclination is here to basically kick this down the road a bit. It's easy to do.
We would strenuously accept.
On what basis?
Your Honor.
On what basis?
The county has been in communication with the respondents since November. The issues here are crystal clear and simple: overgrowth and trash and a fence. There isn't anything different going to be in April than is now. A fence permit doesn't even need an inspection, and the few items of trash is an hour's worth of work.
Yeah, and what do you hope to achieve if I do grant some sort of continuance?
oh, you never see me again. There'll be clarity here. And this one that you refer to as trash was only noticed on February 7th, sir. That's the first time, February 7th. There hasn't even been given 15 days
We'll
to
stipulate to
correct.
that.
This is abusive.
And also, if
given
we could
chance
have a
to
ruling
correct,
on
this is done.
on the evidence before we've been discussing it, and we still don't have it officially
Yeah,
entered
no,
into evidence.
I am prepared to do that as well. Okay, over your objections of due process and not receiving your public records, I am going to accept into evidence the county's exhibits 1 through 26 in this case. The way that process works is you get to see it here, and then any objections you would have made, which you did make, I would consider. And so that's really the gravamen of that. You ought to be able to see it right in front of you. Okay.
And also, Your Honor, I've been handed an exhibit, I believe, Mr. Ott's email said, do you wish to enter this into evidence?
I don't know what you're.
Oh, that's all. Oh, okay, I'm sorry. The bailiff handed it to me, I assumed it was an,
All right.
but we could put it into evidence if you wish, correct, Rachel? Yeah, so we could add that. It's a record of Mr. Ott's emails, communications with the building department dating back to November of last year.
That's Great, just document the public records violations. Good.
No, these are emails back and forth, so there's not a public records issue.
I asked for production on all this stuff prior to this.
Okay, and there is no process of discovery for these hearings, which was what I was trying to tell you. And the public records come out when the public records come out. So, I don't know that there's anything in the material that you gave me that has any evidentiary value. So I think I can return that to you.
Well, I'm asking it be submitted as Exhibit A for my case
Oh.
and take it for the value that it is.
This page or all of it?
All of it, it goes together because you have the date there of February 17 in reference to my initial quote of the code. We can start there.
All right, so.
My Exhibit A.
The county has no objection.
We have no objection to that. The one notice is already in evidence in our,
All right, this is 1, 2, 3, 4, 5, 6, 7 pages of material. It includes what looks like an excerpt. Well, I can't tell that. It's just one page that is from Eric Ott to Eric Ott, emailed to yourself Wednesday, February 19th at 8:36 a.m. It references the case number, ENF 2024-101018-01, and notice dates, it says February 7th, 2025, for the property at 1507 Northeast Satong Avenue, Jensen Beach, Florida. Gives the PCN number and an abbreviated legal description of the property, and that's underneath says General Ordinances, Martin County Code, Section 676.202.c, content of notice to abate shall contain paren 4 and paren a hearing date at least 15 calendar days after the date of notice. And then there's handwriting underneath it that says unavailable for hearing March 10th through 26th, 2025, signed by, apparently, by Mr. Ott. Is that correct?
Yes, sir, just
All right, so
recognizing
that's-
the code.
that's
Thank you
exhibit-
with the notices and reference.
That's Exhibit 1. And then a copy of the amended notice of hearing, 3 pages. That's the one that's dated February 7th for the hearing of February 19th. That's already been submitted by the county. I'm going to make that Exhibit 2. And then the third document is an amended notice of violation, also from February 7th, 2025. That's a 3-page document signed by Ms. Bush on behalf of the county. And I'm going to mark that as Exhibit 3. Okay. So, without objection, I'll accept into evidence the respondent's Exhibits 1, 2, and 3. And over your objection, Mr. Ott, I'm going to accept into evidence the county's Exhibits 1 through 26 in this hearing. Let me look at the documents that are being presented now. These are all emails. I'm looking at an email, and I'll show all of this to you, an email from February 17th from Mr. Ott to Ms. Bush in preparation for the magistrate, I'm going to paraphrase, hearing, provide physically and electronically the following documents, all emails and other communications of those matters and notes, complaints, corresponding communication specifying all trash, debris, and unsightly materials, and then a permit for installation of wooden fence. Wooden fence approved installation permit for 1507 North Satong Avenue. Hearing rules, guidelines, statutes, etc. to govern process. Instructions for subpoenas, magistrate name, email, phone address, and assistant contact information, which none of that is to be provided. Images, including time, date, stamp, validation, defined primary and secondary urban service district, native upland habitat, undisturbed natural growth. That's not relevant to this. All notices of hearing, notices of violation, which presumably you have. Accounting for the 2024 Martin County budget, highlighting all monies for road asset maintenance, not relevant. Unabridged statement of particulars is fully detailed, outlining violation and evidence in a clearly comprehensible manner. That's in the notices. Martin County road map and public land records. And then Florida Statute 177 referencing areas of Ms. Bush's concerns. I don't know how that's relevant. Full contact information for all witnesses and other people with their statements and evidences. There's just the two. And then send email to OTTREJ@AOL.com. As trustee of the Soto Trust, please govern yourself accordingly. Do not cancel the hearing. Produce everything without objection, as time is oppressively of the essence. Please respect unavailability for the process, for all process, February 23rd through March 6th, and March 10th through 27th. Okay. Okay, I think we've done most of that. Okay, good. All right, that's Exhibit 4. Is that what I'm up to?
No, sir, those are ours.
That's our exhibit.
Oh, those are yours. And you want to put those in?
Yes.
Okay.
Like a copy, please.
Yeah, absolutely.
Thank you.
I'm going to mark that as Exhibit 27. We're going to need to make copies of those because, all right,
May we also make copies of whatever the evidence, the one, the 26, so I can,
of course.
thank you, sir.
That's coming off the system, but yes. All right, let's see, this is an email from Ms. Bush to Mr. Ott. Subject is the reference case. It's dated well, I can't tell the date of the actual initial transmission, but the reply from Mr. Ott is dated November 17th, 2024. So the initial, looks probably the initial email says entire property is maintained. There is no known issue other than setting back in place the fence. The right-of-way is county maintained. If you disagree, the 1507 Northeast Santong property has area not mowed. Please advise specifically where images to this email. Number 2, the fence blew over in the hurricane most recent and shall be repaired this coming week. This is a minimal replacement of what exists. Is a permit necessary? And I'm not sure how that fits into this. And then number 3, vehicle is removed. If there are any missing elements noted above, please describe. Please acknowledge if there is a complainer in this case. If yes, there is a complainer, the public record production of the name, address as required by statute, please. Oh, if you would like to meet on the property, just let me know. Thank you, Eric, manager, trustee. Okay, so I misspoke. I thought it was from Ms. Bush, but it's to her. And I see that you just copy yourself routinely, right?
I like to try to keep track of
Yeah,
what's going
okay.
on. Yes.
Fair enough. Good. But it just confused me there a couple of times.
Sorry.
All right, and then oh, I see. No, that's a duplicate of the same transmission in which you actually begin, "Hello, Miss Bush." And that's November 17th, 2024. It is 2 pages, but there's just looks like your name, Eric, manager, trustee, on the second page. I'm going to mark that as Exhibit 5. Is that what I'm up to?
28. It's
Oh,
all
this is yours. 20,
28. I have 27 in my hand.
okay, 28. All right. And we'll get that to Mr. Ott so he can see it. And then on Monday, November 18th,
There it is.
Mr. Ott says, I apologize, actually, it does need to be trimmed up a bit. I just want to make sure we do differentiate between the right-of-way and the private property. That's all the private property right now. We do need to give it some attention, that's fine, we will. I thought the tenant had been taking a little bit better care, but now the fence is down, I can see better. Is there no threshold of minimum repair for the fence? I mean, if we're going to put back basically the same thing, really, is there a line on the ground? Yeah, by December 5th, I was headed over there, and my mower actually broke on another property over the weekend, so we're on the way. Please forward the public record to whoever placed the complaint. Consider this a public records request. Thank you, Eric, manager, TTE. And that looks like it was in response to Ms. Bush's earlier email from the same date of Monday, November 18th, 2024, at 8:34 a.m. Good morning. As you indicated, the property is now in compliance. A permit is required to repair the missing sections. Signed by Tamika Bush. And then there's another copy of the November 17th email, which I already spoken to the record. We'll mark this as Exhibit 29. And there we go. Show that to Mr. Oops, wait a minute. He has another, it's 3 pages. Show that to Mr. Bush, or Mr. Ott. And then we have the November 19th email from Mr. Ott to Ms. Bush, dated 8:40 a.m. Says, good morning, Ms. Bush. We're not going to replace anything. We're just going to put it back, really, and that's 3 panels of a few dozen or so. Again, I asked, does it really reach that threshold? I mean, we'll get it done either way, and I know you want the money, but we're going to put the panels that are on the ground back in position that really requires a permit. Thank you for responding, acknowledging the public records request. I actually need the information and know who Miss Monica is, please. The third thing is that private citizens do not maintain government right-of-way, so that part is absolutely out. And if you want the case law, I had to go to an appellate court to get it. So my name is on it, and I can forward it to you. I don't play in the government land, okay, so we never maintain the right-of-way, and we never will. And that's come down to our, it says appellate court, So you can decide what you really want to do with that. I'm telling you the decision's already been made. If this is something where you want to try it to overturn the court's decision of the state of Florida, please let me know, because this one isn't about us. The law has already been reviewed, reinforced, and therefore been before that legislation. Eric Ott, trustee manager. And Ms. Bush does respond at 10:02 a.m. on November 18th and says, if more than one section is replaced, a permit is required. There is more than one section missing. All the property areas, including the right-of-way, would need to be maintained as it had been previously. The complainant is Monica Marlowe. And that's signed by Tamika Bush. And the page 2 of that is the earlier email that I had mentioned about, I apologize, it actually does need to be trimmed up a bit from Mr. Ott. So I'm going to mark this as County's Exhibit 30.
Mr. Nicoletti?
Yes.
Before we go any further, may I comment on what we've got so far, please?
I would object until all the evidence is heard.
Track of if we just keep rolling. If I can comment on some of the things.
Actually, it'll be better, I think, let me get them all marked, and then we can take the
May I have
time
copies
to
before
go
we
back.
proceed so I can make note?
Absolutely.
Because I'm going to be really lost here if I don't.
No, we don't want that. We want you to
work
be able
with. I
to,
mean, I asked for all this a long time ago, and now I'm still empty-handed.
all right. And the next document,
Well, can I have copies as we go through? So I know it's important to you, I can make notes, I can understand what I'm doing here.
do you want to just make copies of all this? Before I mark them, you'll have to mark them yourself, I guess, but,
Thank you, sir.
okay. Let's take a 5-minute recess, and then we'll be back. Okay, we're back on the record. It's now 11:02. This is a continuation of case number ENF 2024-101018-01. A lot of ones and zeros there. Soto Trust is the respondent, and represented by Five Color FL LLC trustee and Eric Ott as trustee. Parties have all been sworn in. We were considering exhibits that the county was presenting, which constituted several emails back and forth between Mr. Ott and the county. The last one that I have really that has any probative value, there are copies of others here. But the last one I have is dated Tuesday, November 19th, 2024, at 11:12 a.m. from Mr. Ott to Ms. Bush, copied to John Colando and Rachel Spradley concerning the subject of the case. Mr. Ott,
What date are you referring to, please, sir? I'm trying to find.
it's November 19th at 11:12 a.m. And that's at the top of the page. It's
Thank you.
and it says, "Can the permit be done online? If so, if would you send me that information? I'll be very helpful. It is going back into Excella." Is that going back into Excella? Excuse me, if you give me a little guidance, that would be great. And please, I see that is partially legal call out below, quote, exactly where the threshold for this fence comes in. I thought some repairs were so minimal they didn't need a permit. So I'm curious if you help me understand the law, what's the reference? And then a new paragraph, request production for public records has been made, just forward the request, please. New paragraph, when you refer below to 67201A, we are referring to only the grass being cut at 1507 Northeast Sutton, question mark. This is why I ask for specifics. When an entire code is quoted, I don't know exactly what's on your mind that pertains to the code. So please, a little help, that's the idea. When asked for what's the issue, there should be detailed response, not general, please. Thank you, Eric, Manager, TTEE.
Magistrate? May I interject with an email from Ms. Bradley referencing very specifically the fence and permit?
Is it anywhere near this date?
This particular date is 11/19/24 from Rachel Spradley, where she says, yes, if you use the same panels, you will not be required to get a permit as long as they are not new. It copies Tamika Bush and John Colando. This is November 19, 2024.
I don't have that in front of me, but
It's public record if maybe it's pertinent here because Ms. Bradley very clearly, because I did ask Ms. Bush about 3 times,
Yes, sir.
and then Ms. Bradley did come in and say, if you use the same fence, which is what we did, it blew over, we put it up, we used screws, we used the same fence. So I think that the email is pertinent to this particular line of questioning, sir.
that's relevant. I agree.
Okay, thank you.
Except for we have new fence installed.
Okay.
So I told him, yes, if he puts up what fell over, stands back up what fell over, he would not require a permit. However, we have new fence installed. Those are all new panels.
It's a false statement, but, we can get to that detail. I'm just looking for the email now where she says, and then the other interesting.
Your Honor, we'll stipulate that there was an email that said if you replace just the panels, that you don't need a permit, if you replace the old panels. We'll stipulate that email is.
Okay. So it is so stipulated. And let me just continue on with what I'm looking at. On November 19th at 9:45 a.m., Ms. Bush had already sent you an email that said, thank you for reaching out. with your question, while obtaining the permit may seem like an extra step, it is required to ensure compliance. I had already read that into the record, so I'm not going to bother doing it again. And I don't know that the second page is just her signature page. All right, I don't see anything probative there. This is Exhibit 32, is that right?
I think it's 31. Your Honor.
31.
31?
Yes, sir.
All right.
31.
I'm just marking them. You have to mark them as we go along. You got the same pages. This is the November 19th email at 11:12 a.m. from you to Ms. Bush. Can the permit be done online, is how it starts.
5 pages there, we're calling Exhibit 31.
No, I've only marked the one page because the other pages of all parts of other emails that have already been marked.
Okay, right. Okay, so page 3 there, referencing the right-of-way, the difference there. That's where I was going with the statute 177, getting into the Martin County roadway asset map.
Yeah, I think it's already in one of the other exhibits.
Very well, as long as we're covering the content, thank you,
Yeah,
sir.
absolutely. Yep, I know I've already read that in.
Okay.
All right, so,
You can just leave it up there, sir. He's
Okay.
already got a copy, so I'll put it with the rest of it.
okay. All right, so, is there anything else the county wants to produce, or?
Not at this time, but there may, depending on what comes next, there may be something.
Sure, all right. So, Mr. Ott, it's going to kind of flip to you, and tell me again what you need to tell me.
Sure. Going back to your question about the day before discovery or a 119 request is inappropriate. Yeah, it's tough being pushed into these kinds of time constraints. Interestingly, I have here an email dated where did we go here? I've got where Miss Yeah, okay, so January 13, 2025, Sarah Woods is copied here, and she does, let's see, Ms. Bush does then respond January 13th to my public records request saying that you will have these public records. That's January 13, sir. The new notices of February 17, I believed required another communication because I had another amended set of hearing and violation notice. However, the same set of circumstances as described, barring the idea of this trash or whatever came up. That's new, that just showed up on February 7th, first time ever, was already asked for and even brought to the attention of Sarah Woods, who I believe is the Martin County Legal Counsel. So I was trying to get some kind of compliance and production here going for quite some time prior to that. So all of this now showing up here, really, I did make public records requests quite some time.
Okay,
ago.
understand that you're talking about apples and oranges there. The public records requests are fine, and people often use it as a way of obtaining information relevant even to cases, but it operates in a separate venue, and it is not actually required for the conduct of this hearing. What is required for the conduct of the hearing is notice and opportunity to be heard, You may have heard me say that before. And basically, it's a clean slate when it comes to me. I don't know you. I don't know the situation. I haven't heard anything prior to this morning. You've taken a lot of time to worry over tall grass and a piece of fence that required a permit. And you've put us through a lot of hoops, if you will, to make sure, and I was going to make sure, and have made sure, that you had that opportunity to be heard and understand the violation that's been charged by the county. It's pretty simple stuff. The 67201A, weeds and undergrowth, that's basically what they cite when there's tall grass and that sort of thing on the property. 67201B is for trash and outdoor storage of materials that don't belong out there. And then the 105.1 Florida Building Code, whenever there is a permit required, the county ordinance under section 21.1 does refer you back to the Florida Building Code, and it says you have to obtain a permit. So we, those of us who have been doing this a while, understand that, wanted to make sure that you understood it, and maybe the public watching this hearing will get a better understanding of the need for clarity and that sort of thing as far as going forward is concerned. In your case, there was no objection to now the additional exhibits from the county, 27 through 31, and there was no objection to your exhibits 1 through 3. Based upon those exhibits and the testimony that I've heard from you and from the county, I'm going to find that a violations.
I'm giving testimony here. I'm just getting into, I just got discovery. So if you're about to conclude, realistically, this grass here, it's mowed, and Mrs. Bush has acknowledged that, I believe, today. The fence has been repaired. The idea of a fence permit being in any way open, it's the first I'm hearing from it. I thought I saw a date of 2016. This is the first I'm noticing this. Notice of such was not detailed nor described, but there was a general notice given on the 7th. I'm just getting detail now, okay? That fence is permitted. That fence was installed properly. Other details I don't know. All of the real property of 1507 is mowed and neat, and it has been. The car's moved, and she acknowledges this.
Yes,
Everything
that's
I
not
believe.
charged.
Yeah, I believe everything has been complied with, and I would like the opportunity to go through each of these and go through each of these pictures because I haven't even seen these. I have never seen these. I have offered to meet on property. I have asked, even as far as counsel for Martin County in January of 2025 and previously for this information. I'm seeing it for the first time right now today. So I would love the opportunity to go through it because this is, you partially see in this picture is corrected. To the right of the fence, that, according to the Martin County roadway asset map, is Martin County property. Is Martin County property, is Martin County right-of-way, and the code says that the property shall be maintained, only the real property of 1507, okay? This other property, the ownership falls on Martin County. So if there's something to be done there, Martin County would. It's never been mowed, it's natural growth. My questions when I come into, could you please help with definitions for this urban service district, natural upland habitat, undisturbed natural growth? I've never played in the
Your Honor, if I may,
right away.
Tui?
the ordinance specifically makes the property owner responsible for maintaining the right-of-way. as far as providing definitions and everything. I don't think it's the responsibility of the county to conduct the respondent's defense and research. And if we can go up to the overhead photo of the property, I forget which exhibit it is. Oh, there we are. All right, this exhibit here, Your Honor, the outlined area in red is the property. And as you can see, the piece that is in the right-of-way is adjacent to the property on the left side, and that's not mowed. The piece at the bottom is also in the right-of-way and has been maintained. So clearly, the evidence shows by a preponderance that the property owner is responsible for maintaining that piece of grass.
Okay, that depiction, I would tell you, is probably not completely accurate.
Well, that's from the property appraiser.
I understand that, but look where the red line is. It goes through the building.
We noted that. That would be, if I was the property owner, I would be asking the property appraiser about that. But for our purposes, it shows where the property line is and where the right-of-way is. And that's all we're offering it for.
And I suppose really, Mr. Ott, if you were to bring us a survey, and that might be dispositive of it, but you didn't do that today, so.
A survey, you mean, of 1507
Yes.
Northeast Sawton, possibly with a raised seal from Otto Bloomster of Bloomster Professional Land Surveyors, where we have demarcated the right-of-way, which I do believe in accord with Florida Statute 177, Martin County has, as per the traffic division I called over there, they do the maintenance of the roadway owned by Martin County. I believe we have Sawtong and this section of Northeast Dixie Highway. I will need a copy of this, please. Raised seal here, and I can submit this as an exhibit, mark it as pertinent for the flow of
Okay.
exhibits. I would like a copy back, sir.
Show that to Mr. Tui, if you will,
Yes.
It doesn't matter.
because that's maybe directly in response to his argument.
Reiterated in the Martin County roadway map, sir, I do reference here what is Know Your Roads as a public reference created by Martin County. In Martin County, roadways may be owned and maintained by various entities. Here we have the roadway assets map, marking, I believe, in blue, which we can pull up on any public record. It's online. Martin County Traffic Division handles maintenance of the roadways owned by Martin County. Florida Statute 334, Transportation Administration does state that a road as definition does include the right-of-way. All associated sidewalks, roadbed, culverts, etc., the whole thing, routine maintenance includes mowing as defined by Florida statute. In our section 334 here, there's also, when I was asking about the budget, it appears as though there's maintenance money to cover costs and expenses.
Objection, Your Honor, this is irrelevant. The
is statute.
statute, our ordinance, specifically requires the property owner, and I will quote, "For properties located in primary service district and secondary, the provision applies to any areas between the property line of the lot, tract, and parcel and the edge of the roadway."
Yes, to the edge of the roadway.
The exhibit, which I have no objection to,
I have it.
okay, clearly shows the property line, the right-of-way, and the edge of the roadway. And the area that's not mowed is between the property line and the edge of the roadway.
As next evidence, I'd like to submit, please, so you can reference the Know Your Roads and the Florida Statute 334, which I believe should be guidance for the county in terms of the maintenance. They're receiving money, gas money, state tax money, county money to maintain these roads. Can I pass a copy of this exhibit here for?
Yeah, that's a political issue. I certainly don't pretend to know anything about the politics of budget for the county, but I can tell you, looking at the survey, I do see the encroachment of the fence in the right-of-way on the State Road A1A, the Dixie Highway side. And the fence that we're talking about is it on that side? Let's look at the Dixie.
I'm looking, sir.
Is that Sotong that I'm looking at?
Dixie.
This here is Dixie Highway.
That is Dixie Highway?
Yes, sir.
Okay. So there is an encroachment on that side.
The encroachment, sir, has been grandfathered in, to the best of my knowledge. I last sat down with Larry Massing on this, so
Yeah.
it was acquired this way, it's been that way. The permit was taken out and set up this way for a replacement of what was already there, or like a refurbishing many years ago. So I've never been notified there's any issue with the positioning, but you're right. And using the fence as a delineation shows you kind of where the grass is in the right-of-way, which I don't know it meets the nuisance definition really, but it's definitely, the owner would be Martin County, not 1507 Northeast Sotong, as per the definitions of road.
All right, I'm going to take
roadway.
notice of this. I don't think I need to enter it into the exhibits.
No, I agree.
But clearly, it does show that there is some area between your property line and the road right-of-way. The road right-of-way comes back from the pavement and the sidewalk, so. Again, to Mr. Tui's point, is that in the primary area, the service area, the residents are required to maintain that area of vegetation between their property and the roadway, not the right-of-way. Make that distinction clear in your head. It basically is going to take you to not just the sidewalk, but even beyond, because there's a little bit of a swale area there. So every other resident is required, you are required to maintain that area, to mow it, basically, is the charge there. So just be aware of that.
Up to the edge of the right-of-the-way, you say, sir? So at the
No, not-
right-of-way, the
no.
county takes over?
No, that's not correct. To the edge of the roadway, I think is how the wording is.
Yes, to the edge of the road.
Which means if there's a right-of-way between the roadway and your property, you're to maintain that. And that's a really common provision, not just in Martin County, but elsewhere in the country. You maintain that area, even though it's public right-of-way. But you'll see that it is typically part of the lawn, and then there's the sidewalk, and then there's a little bit of a swale area, maybe 3-4 feet of swale, and that also gets maintained by the adjacent property owner. Okay?
Yeah, okay. It looks like the right-of-way is, by Florida statute, is the land which the state, the department, or the county, in this case, the county, owns. We're looking for the owner here. Owns the fee simple. Okay, and has an easement devoted to or required for the use of transportation. Now, the roadway includes the right-of-way and everything else.
Yes.
So really, what it looks like is that this code is saying that up to the point where the county takes over, using tax money and as per the Florida statute, up to the roadway, up to the right-of-way, up to the road, which is defined as this land the county owns, including the sidewalk and the culverts, everything here is per Florida statute, and unless there's something different that I'm not aware of. I'm just
there
going
is.
with the black and white.
Yeah, there is in the ordinance, and it basically says that it's not the right-of-way line that the property owner maintains, it's the property up to the roadway. Those are different definitions, and that means the actual pavement of the road.
Well, the road here, we have the road means a way open to travel to the public, including but not limited to street, highway, or alley. The term includes sidewalks, roadbed, right-of-way, culverts, drains, sluices, includes. The roadway is all of it. The right-of-way is part of, these other components are part of, and the statute says that routine maintenance includes the mowing. Now, we've been diligent and we have complied with the 1507, and the tenants have some of their responsibilities. This has never been an issue before. I don't think that public records will show even any notice of violation before November on this particular property.
So they've taken care of it.
Yeah, we've taken
tenant.
care of, and I believe we have taken care of, and I don't think
Good.
that there is any issue whatsoever. We do maintain the fence is back up, and I was by the property yesterday. These photos are old. There's not a bunch of debris around. We have one tenant who likes to decorate for Halloween and Christmas and stuff, and he puts his stuff away, He makes it nice and neat.
Let me just tell you, I believe I have heard enough, and that I can rule on the issue. And I would tell you that there is enough evidence to show that the violation of the weeds and undergrowth and trash does exist on the property, notwithstanding your argument that, oh, I've taken care of it all. That may be the case, and that's great, because then there won't be any fine.
Yeah,
But-
there's no existence. How do we
But you
prove that?
do need to get the permit for the fence sections that you've installed, not the ones that blew down and got put back up, but any other new sections that got installed.
There are none.
Okay, if that's the case, then there won't be any fine there either.
Well, can we,
Right. But I
maybe we
see,
can address this, because Mrs. Spradley is under the impression that there's something new, and there's not. We
well,
haven't done anything new.
I'm looking at fence section that isn't weathered, that isn't old.
Yeah, we protected it. We're allowed to paint. Knowing that this is getting older, we used a variety of protectants at great expense and went to protect that fence. You can see a difference in the application of the different types
Okay,
even that we applied.
And you still have the permit that expired in 2016 or 17 that has to be dealt with.
This is new to me, okay? This is brand new to me, and if there's an issue, I agree with you. We need to sit down and work it out, but the idea of not giving me information on when I request it by email doesn't work. When I ask for specificity, I really need to know to be able to comply. And then maybe we don't have to see Mr. Nicoletti, because
Yeah.
I try to figure out what they're saying and comply, but if I don't know what's going on, geez, public records that haven't been really even responded to until now, since
Okay,
going
but
back?
Bear in mind, that's not relevant to this.
Well,
I mean, you get to make a public records request, and yes, in fact, they need to be responded to, but it's not part of discovery for this hearing.
is it part of due process?
It is not for this hearing.
Whether or not I have public records, whether or not I have any evidence before me for the hearing doesn't matter as far as.
You've
public-
gotten the notice of the hearing. You've known what the violations have been since November.
No, I have not. That's not true. I've been asking for clarification. These violations have been corrected. I have notice from Ms. Spradley saying, no need for a permit when you put back up the panels that blew over. That's what we did. You're shaking your head. You see that we applied a coating of protectant in a responsible manner to care for the fence. There's nothing new. If she has any evidence or anything, there's something new, I'd love to see it. I don't have any purchase
May I ask
orders.
a question, Your Honor?
Yes?
Can you go back to that photo we just had up, whichever one it was?
This one?
Yeah, okay. Okay, Ms. Ott, referencing the exhibit that's on the screen now, is it your testimony that the dark-colored fence sections and the light-colored fence sections are the same age? Please look at it before answering.
The age of the parts of the fence, I can tell you,
It's a yes or no
are
question.
not new as of the last 2 years, at least, probably more. This fencing goes back to a permit maybe referenced in 2016.
You didn't ask about permits. Answer the question, please. So it's your testimony that the light-colored pieces of fencing were replaced? They are not as old as the dark color.
The fence work that we see from the aerial going all around.
Fence you see right there, were the light-colored pieces replaced?
On Exhibit
No.
14.
So they're,
These pieces go back to 2016 with an original permit. There has been no change. There has been no replacement. There are different ages of the fence. The permit, you'll probably notice, going back to 2016, was a working with what was already there type of a permit. This is not a new installation. The property as acquired already had a fence.
Permit is
So there's a mix
expired.
of ages with whatever's there, but nothing was done recently, and no panels have been installed, no new fencing since this permit going back to, I believe it's 2016. That's my testimony. We've put up the new stuff, we've treated what was there, but we haven't started dropping in a whole bunch of new panels and things. To the best of my knowledge, no, sir, not other than the permit compliance that we had. That's the best of what I understand on the fence situation.
I'm satisfied that there's a fence on that property with no permit, and it needs to be addressed. And the county has determined that the permit expired in 2016, and it does need to be addressed. The fact that you did not know it is not the county's problem. It is not, it's your problem.
What's the issue then? Can we look at the detail?
I can tell you this,
Yeah.
that I am about to rule, and I am going to find that violations as charged do exist on the property. I'm going to accept into evidence the county's exhibits 1 through 31, as discussed before, respondents' exhibits 1 through 3, as discussed. I'm going to find that violations as charged do exist on the property and order compliance on or before March 31st, 2025, failing which a fine in the amount of $100 per violation per day will accrue, and I am going to award costs in the amount of $575 to the county to be paid at the conclusion of this hearing. And we have taken so much more time than we ever should have taken on tall grass and no fence permit. So I hope that you do what you need to do as far as getting the permits and cleaning up that property. And that's it. Thank you. Okay. Back to
to reality.
the first case on the docket. It's Sublime Holdings LLC, ENF 2024-060166. And Officer Counselor, you're going to present, and let's see, let me just get back up there.
Should be a stipulation agreement, Your Honor.
I'm looking.
Okay,
There it is. Got it. Thank you.
perfect.
And that's a stip. Okay. Whenever you're ready, go ahead.
My name is Chris Counselor. I've been sworn in. I am a code compliance investigator for Martin County. The respondent, Sublime Holding LLC, is not present but has entered into a stipulation agreement. This case concerns the property at 3304 Southwest 72nd Avenue located within Palm City, which is located within Martin County, Florida. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, property owner is Sublime Holdings LLC. A copy of the property appraiser's records, County Exhibit 1. On June 6, 2024, Officer Frank Marcos inspected the property. At the time, he observed property being used as a storage yard of random items and not being used for as ag use. At the time, he photographed the property. The photographs accurately show what he saw then, which will be County Exhibits 2, 3, 4, and 5. So 2, basically, we have a storage area of these railroad ties. 3, that's far away view. Exhibit 4, just other piles of the railroad ties being stored on the property. And Exhibit 5 is just Officer Marcos's door tag and just a mailbox with the address. Based upon the investigation, he issued a notice of violation to Sublime Holdings LLC on August 1st, 2024, marked as County Exhibit 6. In the notice, he cited the following Martin County Code violations: Section 3.421 M2 Industrial District and Section 67.201B for nuisance declared trash and debris. In the notice of violation, the respondent was given until September 3rd, 2024 to correct the violation and was informed of the need to contact code enforcement. I took over the case in November of 2024. On November 12th, 2024, I inspected the property. At that time, I observed that the property was still being used as a storage yard and that random items and the items stored on the property were not being used or intended for an ag purpose. At the time I photographed the property, the photographs I accurately show what I saw then. It's marked as County Exhibits 7, 8, and 9. 7 is basically the building on the property. Exhibit 8, the railroad ties are still on the property, along with Exhibit 9. Since compliance was not achieved, a notice of hearing was issued by certified mail on December 3rd, 2024, and marked as County Exhibit 11. I spoke with the owner and met with, and an extension was granted. Compliance was still not achieved, so on January 30th, 2025, an amended notice of violation and an amended notice of hearing were issued by certified mail and marked as County's Exhibits 12 and 13. This was the amended notice of violation and the amended notice of hearing.
Okay.
Yes. Okay. I updated the code violations in my amended to include, I took off the industrial zoning and cited it basically for Section 3.11 for permitted uses, as the property wasn't being used for an ag purpose, and I kept the Section 67.201B for nuisance declared trash. The return receipt was not received, so on February 6, 2025, I hand-delivered the posting to the owner of the property. An affidavit of hand delivery is County Exhibit 14. I went to the property yesterday. I have met with the owner and discussed the violations and what needed to be done to correct them. Therefore, on February 18, 2025, the owner entered into a stipulation agreement to get more time, and the $350 administration fee was paid upon signing of the agreement. Exhibits 15, 16, 7 are just photos that I took prior to the signing of the stipulation agreement showing that the property was still in violation. That's the main building, random items in the property, and the railroad ties are still there. But the owner has entered into a stipulation agreement, and based upon the testimony and evidence, I request that the respondent, Sublime Holdings LLC, be ordered to comply with the set of provisions of the Martin County Code by the agreed-upon June 1st, 2025 date, and if not compliance by then, be required to pay a fine in the amount of $100 per day per violation until compliance is achieved.
Okay.
And that concludes my testimony.
And let's see. Do we have a signed copy by Mr.
He signed it electronically.
Lee?
That's why it looks funny on the thing. It was signed electronically.
Really?
Yes, sir.
I've never seen an electronic signature like that. Okay. All right, note for the record that the stipulation does require a June 1st compliance, and that $350 in administrative costs have been paid to the county. So without objection, I'm going to accept in evidence the county's Exhibits 1 through 17 in this case. Based upon the stipulation presented, I'm going to find it is appropriate to enter an agreed order in this case, and note for the record that Mr. Officer Counselor has executed on behalf of the county, and that Dean Lavalley, as owner of the property, has executed a little differently by basically typing his name into the signature line. And it's so ordered.
Thank you.
Okay. Let's see. Wait a minute.
That one was removed, Your Honor.
Florida Affordable Housing?
Correct.
Okay, is removed. All right, and that brings us to the Farrell case. And this is case number ENF 2024-0504, 31-01. Leonard and Kenneth Farrell are the owners. And Ms. Espiat, you're going to testify if you raise your right hand. Do you swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay. What do we got?
My name is Maria Espio, and I have been sworn in. I'm a code compliance investigator for Martin County. The respondents, Leonard Farrell and Kenneth Farrell Sr., are not present. This case concerns a property at 5649 Southeast Indigo Avenue in Stuart, Florida, in Martin County, Florida. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owners are Leonard M. Farrell and Kenneth Farrell Sr. A copy of the property appraiser's record of ownership is County's Exhibit 1. On May 16, 2024, Officer Counselor inspected the property. At that time, he observed roof damage, a broken tarp on a roof on the roof, accessory structure that was damaged, and trash. At that time, he photographed the property. The photographs accurately show what he saw then, marked as County's Exhibits 2 through 6. 2 is the roof with the roof tarp. 3 is a different angle, and you see more damage here.
On the soffit. Yeah.
Correct. 4, more soffit damage. 5, trash, and this is the accessory structure. And 6 is just a view of the yard. Based upon the investigation, he issued a notice of violation to the owners on July 10th, 2024, marked as County's Exhibit Number 7. In the notice, he cited the following Martin County Code violations: Section 67.201B, nuisance declared trash, etc., General Ordinances, Martin County Code. Section 21.115, roofs and drainage, General Ordinances, Martin County Code. And Section 21.99, accessory structures, General Ordinances, Martin County Code. In the notice of violation, the respondents were given until July 25th, 2024 to correct the violations and were informed of the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved, and a notice of hearing was issued by certified mail on August 22nd, 2024, marked as County's Exhibit 8. Officer Counselor was informed that both owners had passed away, therefore he removed this case from the September 2024 hearing to give it time to see if the new owners would appear or a probate case. Once I took over the case, I checked for a roof permit and new owners or any changes and found none. Therefore, I amended the notice to appear for the February 2025 hearing and mailed it by certified mail and regular mail, January 27, 2025. The amended notice is marked as County's Exhibit 9. The return receipt was not returned, therefore I posted the property on February 4th, 2025. The affidavit of posting is marked as County's Exhibit 10. Therefore, I went back to the property again on February 18th, 2025, and saw the cited violations had not been corrected. I checked for new permits and found none. The inspection photo and permit history are marked as county's exhibits 11 through 15. 11, the accessory structure, that one has been complied, so that's off the order. 12, the roof is still, remains damaged and tarped. 13, trash in the back. 14, a different angle, you could see part of the roof is falling down. And 15 is the permit history. On record type, you can see there's no permits. I requested all of the county's exhibits be received into evidence. Based upon the testimony and evidence, I requested the respondents be ordered to comply with the cited provisions of the Martin County Code by March 31st, 2025, and if not in compliance by then, be ordered to pay a fine in the amount of $100 per violation for every day the violations continue thereafter. The county has incurred a cost in the amount of $575 conducting this investigation and requested the county be reimbursed this amount at the conclusion of today's hearing.
Okay, anybody here on behalf of the Farrell family or owners of the property? Looking out, seeing none. Have you had any contact with anybody?
Yes, with the management company, but no permits. They're aware of what they needed to do, but no permits have been pulled.
Okay. All right. Yeah, I was wondering, there looks like there is somebody taking care of the property.
Yes, they mow most of it.
Okay. All right. Still no one here on behalf of the Farrell family. Let's see, without objection, I'll accept into evidence the county's exhibits 1 through 15 in this case. Based upon that evidence and your testimony, I'll find that violations of 67-201B and 21.115 roofs does exist on the property, or do exist. In order compliance on or before March 31st, 2025, failing which a fine in the amount of $100 per day will accrue, and I'll further award costs in the amount of $575 to be paid to the county at the conclusion of this hearing.
Thank you.
Yes, ma'am. Okay, let's see, we've got a bunch of orders imposing penalties. And Officer Fisher, you've got those cases. Let's see, it's, what about the,
Mr. Nicoletti?
Yeah.
The docket cover sheet has the owner of the property's name on it. The owner, they're in order for you up there. That's who we actually sent this citation to. So what the docket cover page does is pull the property owner for where he caught them doing the work. It won't let us put the actual person who we violated with the citation on the docket cover page. Does that make sense?
yeah, it makes sense, but it's,
They're trying to figure out how to get it so that we can pull it the other way, so when we put in that it's a violator instead of the owner, but they're having some kinks in the cover page.
all right, so I'm looking at case ENF 2024-05005001, and the respondent is Nadine Rotundo for engaging in business without a license, but under that same order, it's issued to James Stephen Decker, the owner of the property.
No, sir. Nadine is the owner of the property. James is.
Other way around.
Issued the citation to.
Other way around.
Yes, sir. So the docket cover page pulls who owns the property
Okay.
where we found the unlicensed work.
I'm going to strike Miss Rotundo's name and put James Stephen Decker. All right, so what did Mr. Decker do, Mr. Fisher? Raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God?
I swear.
Okay, what do we got?
Good morning, Your Honor.
Well, maybe. For 9 minutes more.
My name is Nicholas Fisher, and I have been sworn in. I'm a code compliance investigator for Martin County. This case concerns the citation case ENF 2024-050050 against James Stephen Decker. Mr. Decker was issued a citation for violation of County's Ordinance Section 43.49, subsection A, subsection 5, engage in business without a license, General Ordinances, Martin County Code. The citation issued to Mr. Decker is County's Exhibit Number 1.
Oh, that's not easy to read, is it?
No, sir. So the citations, when they're handwritten, it's a carbon copy citation. So the front-facing one, which is most legible, is given to the violator. The second undercopy is my retaining one.
Okay.
A copy of the property appraiser's record of ownership for James Stephen Decker is County's Exhibit Number 2. Mr. Decker did not request to contest the citation. Therefore, the county requests the citation be upheld and the order imposing penalty/lien be accepted.
All right. We've got Exhibits 1 and 2, and Mr. Decker is not here. So without objection, I'll accept into evidence the county's Exhibits 1 and 2 in this case. Based upon that evidence in your testimony, I'll find that it's appropriate to impose a penalty and a fine in the amount of $500 for Mr. Decker's failure to obtain a license to do business. Okay. Next one is ENF 2024-050262-01. And looks like the respondent is Nicholas Joseph Penavolpe. Penavolpe. Okay, and what did Mr. Penavolpe do?
My name is Nicholas Fisher, and I have been sworn in. I'm a code compliance investigator for Martin County. This case concerns the citation case ENF 2024-050262 against Nicholas Joseph Penavolpe. Mr. Penavolpe was issued a citation for violation of County's Ordinance Section 43.49, subsection A, subsection 5, engage in business without a license, General Ordinances, Martin County Code. The citation issued to Mr. Penavolpe is County's Exhibit Number 1. A copy of the property appraiser's record of ownership for Nicholas Joseph Penavolpe is County's Exhibit Number 2. This is a Port St. Lucie property appraiser's record of ownership.
What was he doing?
So for this particular case, he was an unlicensed window and door subcontractor that was hired by an owner builder for a new single-family home build down in Hope Sound, and he was putting in the windows without a license.
All right.
A valid Martin County license or state contractor's license.
Okay. All right. And anybody here on behalf of Mr. Penavolpe? Seeing no one, I'll accept into evidence the county's Exhibits 1 and 2 in this case and find that it is appropriate to impose fine in the amount of $500. And the third one is Willie F. Jackson. And it's case, well, you're going to recite the case number anyway. All right, so it's Willie F. Jackson, and whenever you're ready, go ahead.
My name is Nicholas Fisher, and I have been sworn in. I'm a code compliance investigator for Martin County. This case concerns the citation case ENF 2024-060298-01 against Willie F. Jackson. Mr. Jackson was issued a citation by certified mail for violation of county's ordinance section 43.49, subsection A, subsection 5, engage in business without a license, General Ordinances, Martin County Code. The citation was issued to Mr. Jackson, is County's Exhibit Number 1.
Okay, and what did he do?
He was an unlicensed installation contractor engaging into business in Martin County. He appeared on one of our interdepartment subcontractors lists from a homeowner builder permit, and he was trying to do the work without a license.
Okay.
A copy of the property appraiser's record of ownership for Willie F. Jackson is County Exhibit Number 2. And this is I believe, a physical copy.
And in Lake Park?
Correct.
Okay.
Copy of the return receipt is County Exhibit Number 3. Mr. Jackson did not request to contest the citation, therefore the county's requests the citation be upheld and the order imposing penalty/lien be accepted.
Okay, Mr. Jackson, anybody here on behalf of Willie F. Jackson? Seeing no one, without objection, I'll accept into evidence the county's Exhibits 1 through 3 in this case. Based upon that evidence and your testimony, I'll find it is appropriate to impose a fine in the amount of $500 in this case. Okay. All right, the next one is Julio Yonke, and it's, let's see, Bernach. Okay. Junki. Okay, whenever you're ready, go ahead.
My name is Nicholas Fisher, and I have been sworn in. I'm a code compliance investigator for Martin County. This case concerns the citation case ENF 2024-090-482-01 against Julio Junki. Mr. Junki was issued a citation by certified mail for violation of County's Ordinance Section 43.49, subsection A, subsection 5, engage in business without a license, General Ordinances, Martin County Code. The citation issued to Mr. Junki is County's Exhibit Number 1.
Okay, building and deck. Okay,
A copy of the property appraiser's record of ownership for Julio Junki is County Exhibit Number 2. This is from Miami-Dade. Property appraiser, pardon me.
okay,
A copy of the return receipt was signed and is County's Exhibit Number 3. Mr. Junki did not request to contest the citation, therefore the county requests the citation be upheld and the order imposing penalty/lien be accepted.
okay, anybody here on behalf of Julio Yonke? Seeing no one, without objection, I'll accept into evidence the county's Exhibits 1 through 3 in this case. Based upon the evidence and your testimony, I'll find that it is appropriate to impose a fine in the amount of $500 in this matter. And hang on just a sec. Okay. Next one is David F. Culberson, and that's for this one, okay.
Why did he pull this owning person?
Okay, go ahead.
My name is Nicholas Fisher and I have been sworn in. I'm a code compliance investigator for Martin County. This case concerns the citation case ENF 2024-110231-01 against David F. Culberson. Mr. Culberson was issued a citation by certified mail for violation of County's Ordinance Section 43.49, subsection A, subsection 5, engage in business without a license, General Ordinances, Martin County Code. The citation issued to Mr. Culberson is County's Exhibit Number 1.
Build a retaining wall, okay.
A A copy of the property appraiser's record of ownership for David F. Culberson is County's Exhibit Number 2. A copy of the return receipt was signed and is County's Exhibit Number 3. Mr. Culberson did not request to contest the citation, therefore the county requests the citation be upheld and the order imposing penalty/lien be accepted.
Okay. Mr. Culberson, David F. Culberson. Anybody here? Nope. So without objection, I'll accept into evidence the county's Exhibits 1 through 3 in this case. Based upon the evidence in your testimony, I find it is appropriate to impose a fine in the amount of $500 against Mr. Culberson. Okay. That takes care of those. We've got one case left, the Boyle case. Oh, that's you, Ms. Bush.
Yes, sir.
Okay. Oh, and that's a stipulation. Okay, great. What do we got? And this is case ENF 2024-080715. James M. Boyle is the property owner.
My name is Tamika Bush, and I have been sworn in. I'm a co-compliance investigator for Martin County. The respondent, James M. Boyle, is not present. This case concerns the property at 2580 Northeast Marion Street in Jensen Beach, Florida, 34957 in Martin County, Florida. This case was not generated from an anonymous complaint, and according to the official records of the property appraiser of Martin County, the property owner is James M. Boyle. A copy of the property appraiser's record of ownership is County's Exhibit 1.
Okay?
On August 27, 2024, the property was inspected, and at that time, code enforcement investigator observed siding surrounding the garage door, no permits on file, and missing house numbers. The house numbers violation is now in compliance. At that time, the property was photographed. The photograph accurately shows what was seen and is marked as County's Exhibit 2. So it's the siding around the garage area that requires a permit.
Gotcha.
Based upon the investigation, I issued a notice of violation to James M. Boyle on August 28, 2024, marked as County's Exhibit 3. And in the notice, the following Martin County violations were cited: Sections 104.1 FBC, permits when required, incorporated by Sections 21.1 General Ordinances of Martin County Code. In the notice of violation, the respondent was given until September 27, 2024 to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved, and a notice of hearing was issued by certified mail on January 24, 2025, and is marked as County's Exhibit 4. The property permit screenshot is marked as County's Exhibit 5. And this shows that there was no permit applied for the siding work.
Okay. And not under the residential remodel, right?
Well, he initially did it under a remodel, and I think, from my understanding and speaking with him, he hired an engineer, and I think they're resubmitting under a different type of permit. Also, this permit hasn't been issued. It was still waiting on applicant.
Okay, I was just wondering whether it could be included in that remodel permit, maybe. But it hasn't been issued nonetheless. Okay,
The return receipt was not received, and the property and county administration was posted on January 30th, 2025, and is marked as County's Exhibit 6. And the affidavit of posting is marked as County's Exhibit 7.
okay,
On February 7, 2025, the owner, James M. Boyle, entered into a stipulation of agreement. The owner has paid the agreed administrative cost of $350. The owner agrees to come into compliance with the cited provisions of the Martin County Code by June 30th, 2025, and if not in compliance by then, be required to pay a fine in the amount of $100 for every day the violation continues thereafter. I request that all the county's exhibits be received into evidence.
Okay. All right, so without objection, I'll accept into evidence the county's exhibits 1 through 7 in this case, based upon the stipulation and evidence. I'll find that it is appropriate to enter the agreed order in this case, ordering compliance on or before June 30th, 2025, failing which a fine in the amount of $100 per day will accrue. And further note for the record that $350 has been paid to the county for costs in this matter. The stipulation is signed by James M. Boyle on behalf of himself and by Ms. Bush on behalf of the county. And so I'll go ahead and enter the order.
Thank you, Special Magistrate.
Thank you. All right. I do not have the minutes, so.
Because you were going to review December's. So I do still have those that need to be.
I
I don't know
do.
if you made it through those.
I actually have not. So we're going to have two
So
sets,
December and January then.
and now February.
Yes. So December, January, and February.
Okay, all right. So we'll have three sets of minutes to approve at the next hearing, which is on
The 19th.
19th?
Yes. March 19th.
March 19th is the next hearing, and we will hopefully see you all then. Thank you very much.
Thank you.